So, today I want to discuss how Roe v. Wade was legally justified before it was overturned. Now, last time I talked about the inadequacy of the state to protect rights. And today I want to elaborate a little bit on how the state justified its legal argument for the Roe v. Wade decision, as well as explore possible alternative ways that abortion rights could have been codified by the Supreme Court. Now, I believe that this is useful for a few different reasons. First, I believe it gives us an understanding of critiquing the former state opinion from a leftist, anarchist, or feminist perspective. Second, I believe it allows us to understand which other laws and rights may be subject to similar attacks from the Supreme Court, and to understand the court's current strategy of curtailing rights. Now, finally, it offers us a weak alternative argument to present to statists as a sort of compromise, in order to try to protect those who will suffer most from such rights being made illegal. So, I will elaborate on the former two in the next videos. However, the latter should be covered quite extensively over the course of exploring the legal justifications in this video. So the decision in Roe v. Wade relied primarily on the justification that a pregnant individual has the right to privacy with a physician, as well as in terms of matters of marriage and family life. While no amendment to the US Constitution explicitly defines a right to privacy, over the years different amendments have been understood to implicitly provide such a right to privacy. The Third Amendment, for example, which denies soldiers the ability to quarter in people's homes without consent, is implicitly taken as a right to privacy of the home. In the case of Roe v. Wade, numerous amendments were appealed to during the case for that privacy justification. However, the most compelling of these to the courts was the 14th Amendment. Now, it's worth mentioning that the 14th Amendment has been used as the legal justification for a lot of civil rights cases. The relevant passage of the 14th Amendment is in its first section, where it states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." It is the liberty under this section of the 14th Amendment that is used to imply a right to privacy, as at the time, the court recognized the expanding understanding of what provides liberty given social conditions. Now, this particular understanding may be overturned in the current reality that we live in, with the Dobbs decision having come down. But in the time where Roe was passed, it was understood that the idea of liberty was constantly expanding based on social conditions, and as social conditions changed, that would eventually bring about new understandings of how to apply liberty. And thus, privacy in this instance was taken as a justification of that liberty. So while the courts did grant this right to privacy, it did also restrict it within the very same ruling. Now, we can take a look at the actual court documentation, where at the top we can see that it's explained that a pregnant individual does not have the right to terminate whatever time in whatever way for whatever reason. The reason for that is that the state has an interest after a certain point. Specifically, the point of interest involves the state's desire to preserve health and to preserve the quote potential life of the fetus. In fact, the court specifically states that this decision for a person to have an abortion is not absolute. The compromise that the court provides, which I feel is an inadequate one, the court provides this compromise that decides that a pregnant individual is allowed to have full privacy during only the first trimester of pregnancy, while allowing some state restrictions to begin during the second trimester. Now, it's worth noting a substantial flaw in this ruling, one that Justice Alito attacks fiercely in the Dobbs decision that has overturned Roe. The decision in Roe didn't actually tie abortion rights or the right to choose directly to the Constitution. Instead, the argument sidesteps things by appealing to privacy and then linking that to liberty without actually defining the nature of the privacy and the liberty that protects abortion rights. Further, it rules that the privacy is not absolute, as I stated, within the exact same ruling. And since that privacy ends when the state's interest takes over at the moment of viability of a fetus, it offers a kind of rebuttal to this fundamental right if the definitions of either viability or privacy were ever to be changed or challenged. In this way, it's actually reframed the debate throughout the past 50 years around the ruling, not as one of the rights of the pregnant individual, but one of the medical care and the moral interpretation of the potential rights of a fetus. Essentially, the way the decision's framed, it creates a lot of questions of its legal status that may not have been intended in the original ruling. And it's through these forms that Alito was basically able to create his opinion. The way that this has been overturned, at least through conservative rulings, has been to justify it by pretty much criticizing these exact flaws within the Roe decision. Now, the better ruling in this instance probably would have been to define rights via equality. But that's something that I'll discuss further when talking about some of the alternatives and the ways that it could have also been justified. Now, in addition, the privacy that was protected in the ruling is not generally framed as the right of the pregnant individual. The right to choose was instead tied to the medical professional. This is shown through the state interest in health, as well as describing things consistently through the lens of seeking a physician's approval. As an example, during the court opinion, we can see an area where it says for the period of pregnancy prior to this compelling point, the compelling point later is deemed to be the point of viability of the fetus, the attending physician, in consultation with his patient, is free to determine without regulation by the state that in his medical judgment, the patient's pregnancy should be terminated. If the decision is reached, the judgment may be effectuated by an abortion free of interference by the state. The phrasing here seems to indicate that it was the physician whose rights were violated due to their inability to practice medicine and due to the violation of doctor patient confidentiality. We can actually see that Ruth Bader Ginsburg actually had a very similar criticism of Roe. We have here an article from University of Chicago where it quotes Ruth Bader Ginsburg, where she says, "My criticism of Roe is that it seemed to have stopped the momentum on the side of change. She would have preferred that abortion rights be secured more gradually in a process that included state legislatures and the courts," she added. Ginsburg was also troubled that the focus on Roe was on a right to privacy rather than women's rights. Roe isn't really about the woman's choice, is it? Ginsburg said. It's about the doctor's freedom to practice. It wasn't woman-centered, it was physician-centered. So, in short, the Roe v. Wade decision was a bit of a mess, and as Ruth Ginsburg stated, as well as many other pro-choice advocates over the years, there were better arguments here. So now I want to discuss some of those alternative justifications for abortion rights under the US Constitution. It's worth noting that the legal argument presented by Roe and her legal team specifically did appeal to the right to privacy in their argument. So while the alternative arguments may be more sound, they could not really have come from the Roe decision itself unless the legal team had proposed them, or one of the Supreme Court judges had justified Roe in these specific ways. Now, it is worth noting that Ruth Bader Ginsburg had actually been working on a case where she was trying to define abortion rights through the right to equality. That said, these arguments are ones that had tried to improve upon the ruling of Roe and to overcome some of its failings to specifically define abortion as tied to the Constitution and not rely exclusively on this flimsy privacy argument. So the first of these arguments that I want to talk about is presented by Sylvia Law, where she provides an argument based around sex equality that ties either to the 14th Amendment or the proposed but never passed Equal Rights Amendment. So for those of you who are not aware, the Equal Rights Amendment was written to provide equality based on sex. Now, a lot of the rulings that hinge on privacy today would likely be covered under such an Equal Rights Amendment. As Sylvia Law puts it, a proposed Equal Rights Amendment would make it so that sex is not a permissible factor in determining the legal right of women or of men. The only case where sex could be a determining factor is when it would create more neutral and equitable outcomes. For example, someone with a uterus would not be required to remain pregnant simply because someone without one cannot be pregnant. This would mean that an abortion would need to be legal in order to create this equality. As we can see, this would be an easy argument for grounding the equal rights for abortion. That said, similar arguments about sex would make for easy justifications for things like gay marriage, contraception, and trans rights. However, we don't have that Equal Rights Amendment. The conservatives saw to that. So Sylvia Law's argument gets dialed back quite a bit, actually, to a 14th Amendment justification. Not that that isn't a sufficient justification, it's just that it doesn't provide that same grounding. However, the equality based through the 14th Amendment is more or less provided on the exact same logical lines. Another alternative theory that provides protection under the 14th Amendment was proposed by one Dan Reagan. Reagan's argument is that equal protection is applicable since nobody can be compelled to give aid to another person. This does two things. First, it makes a case for abortion on the principle that a pregnant individual does not have to provide aid to a fetus, since no other human being besides a pregnant individual is ever expected by law to provide such aid. The example that Reagan uses is a person who was not able to be compelled by law to provide a bone marrow transplant to his own cousin. The second thing that it does is that it provides an argument of personhood to the fetus. Now, this is purposefully done by Reagan in order to show that a pregnant individual does not have to provide care for the fetus, regardless of personhood. While this argument does a lot better than Roe at establishing bodily autonomy as the primary justification, the concession of the life of the fetus does a lot of harm that I feel would have created a lot of long term implications. This is simply because the argument doesn't address the moral and social ramifications of such an acknowledgement. Just because someone isn't compelled to do something doesn't mean that they can't be shamed socially into doing it. And given that that's been the primary tactic of a lot of anti abortion activists over the years, I can guarantee you that this would have manifested very similarly had this been the legal justification. Further, it would have been overturned in quite a similar manner. So, a third justification that we can look at is presented by Andrew Koppelman, who uses the 13th Amendment to defend abortion. The 13th Amendment effectively made slavery and involuntary servitude illegal, except in the case of a prison sentence. So Koppelman goes through a number of scenarios that compares pregnancy to contract labor. He argues that the possibility of pregnancy through sex is in fact not a contract to take care of the fetus. Further, he argues that while a poor person can change employers theoretically, technically speaking, the pregnant individual cannot change the nature of their servitude, and therefore it's involuntary. This argument is unfortunately relevant, since the Supreme Court has actually dictated over the years that economic need may force people to work jobs that they actually don't want to. In the end, Koppelman tries to argue that since there is no contract, that a pregnant individual being forced to carry a child would in fact be a case of involuntary servitude, and thus would violate the 13th Amendment. What both Koppelman and Reagan tried to do in these two arguments is to develop an argument where the supposed right to life of the fetus can be disputed legally by asserting bodily autonomy as the most important right being violated, even to someone who believes that the fetus is in fact alive. While these are both compelling, I think the most compelling one is the perspective of David H. Guns, who argues that bodily autonomy and abortion rights are actually tied to an originalist understanding of the 14th Amendment. Now, the specific usage of originalist here is actually quite important within a very liberal and conservative debate framework, especially as conservative court justices have positioned themselves, especially those under the Federalist Society, they've positioned themselves as originalists and have used that framing to deny civil rights and to try to bring us back effectively to pre-New Deal standards. The reason that this is interpreted as originalist is because the 14th Amendment was written to attempt to legalize the right to equality for formerly enslaved people. We can already see how that is in and of itself an issue of bodily autonomy. However, reproductive justice comes into play when we look at the reality that most women who faced enslavement basically had to deal with white slaveholding men controlling their bodily autonomies, both through rape and sexual assault, as well as determining when and who they were to have children with, and the children that they did have were then the property of these slaveholding men. It is the ability to control one's body and family planning that was part of the justification for the 14th Amendment itself. We can actually see that in an article by The Atlantic, where they talk about this extensively. The rights to control one's body, establish a family, and have children necessarily safeguard the right to abortion as a fundamental right. The right of having, quote, having a family, a wife, children, home, etc., as Senator Jacob Howard, who played a central role in drafting the 14th Amendment, put it, guarantees to the individual free choice in matters of family and childbirth. In the same way that the freedom of speech also includes the right to not speak. The right to bear and raise children and the right to abortion are two sides of the same coin, both integral parts of reproductive freedom. In our constitutional heritage, laws that prohibit abortion and those that compel abortion are equally offensive to bodily integrity, autonomy, and equal dignity. And so, the great part about this justification and why I like it so much is it not only deals with the right to have an abortion, but the right to not have one by state implementation. Because we are also talking about a history where there have been people who have been compelled by the state to basically lose their reproductive freedoms. They've had all of that taken away through things like forced sterilization. And so when we look at the way this is justified, it gets rid of forced sterilization and in addition provides the ability for people to actually get access to abortion when they want it. And so that is a really compelling aspect of this particular justification. Protecting people's reproductive liberty was very much a part of the effort to define what it meant to be enslaved or to be free. One of slavery's cruelest aspects was the brutal denial of reproductive autonomy in matters of family life. Plantation owners forced enslaved women to bear children who would be born into bondage. Rape and other forms of coerced procreation enabled the growth of the institution of slavery, even after the international slave trade was outlawed in 1808. Slavery is terrible for men, wrote Harriet Jacobs in the 1861 narrative of her enslavement, but it is far more terrible for women. Jacobs' autobiography, as the intellectual Henry Louis Gates has observed, demonstrated how enslaved women were treated as objects to be raped, bred, or abused. Not only were they enslaved people coerced into bearing children, enslaved people in loving relationships had no right to marry or raise children of their own. A spouse or a child could be sold on a whim, and untold numbers were. Family separations were endemic to slavery. About half of enslaved people sold on the interstate market were forced to leave behind a spouse or a parent. True freedom, as it's shown here, would be impossible without securing those freed from enslavement the right to be protected in their homes and families, said Senator John Sherman. Because reproductive freedom and family life were impossible, where the wife is the property of the husband's master and may be used at will, and where children are bred like stock for sale. Representative Thomas Eliot argued, no act of ours can fitly enforce their freedom that does not contemplate for them the security of home. So it is through this justification that we can see that the idea of somebody being forced to be an incubator by the state is in fact prevented through the 14th Amendment. And it's worth mentioning here that this particular original intent, this particular understanding that was cited by senators at the time that this particular document was put out, will likely be ignored as it involves the history of people of color. And it's honestly inconvenient for this conservative court's agenda. And that's why, again, it'll be ignored. However, if we do need a legal justification outside of the creation of a specific equal rights amendment, I find this originalist interpretation of the 14th Amendment to be extremely compelling and a great justification. That said, as an anarchist, I don't tend to believe that we need to legally ground ourselves for justification in a constitution. So I hope you will join me next time where I bring forward an anarchist and feminist lens to analyzing Roe v. Wade from the left and explain why Roe v. Wade is actually a violation of bodily autonomy. So with that said, if you've enjoyed what you've watched, do consider liking the video, subscribing, and leaving a comment, as well as consider joining my Discord. If you're in a financial place to do so, and only if you're in a financial place to do so, please do consider supporting me on Patreon, especially as political content like this can often be demonetized on YouTube. The links for everything that I've mentioned are in the description down below. With that said, my name is Anarchist Tara, and I thank you for watching.